Welcome to Shepherd and Wedderburn series of webinars covering disputes in Scotland. My name is Elaine Brailsford, and together with my colleagues Stephanie Hepburn, Gina Johnson and Thomas McFarlane, we will provide a high-level overview of Scottish civil procedure. If you are a solicitor in another jurisdiction, you'll be familiar with your own court procedure, but you may have a requirement to understand the Scottish system. If you are an in-house solicitor in a business where you will cover a range of legal work, you won't necessarily live and breathe the court procedure that we do. Or maybe you're a business that doesn't have an in-house solicitor, in which case you may be managing disputes yourself up to a certain level. Whatever the reason for tuning in, we hope this gives you a useful overview of Scottish court procedure as we cover topics that are relevant to disputes, including privilege and confidentiality, prescription, disclosure, remedies and enforcement, each of which have their own particular Scottish slant because, as you probably know, we do things a bit differently up here. So what follows is a very short history of Scots law. The differences are attributable to the unique history of our legal system. It might all have been so very different if Alexander III, King of Scots, had not been thrown to his death from his horse down a cliff on the stormy night of 18th March 1286. In the 100 years or so up until then, Scotland's legal development followed a path which can fairly be described as converging with that of its larger and richer neighbour, England. Had Alexander had a son to succeed him, this path might well have continued, but he left no son, and instead his heir was his granddaughter, the Maid of Norway, who was 3 years old. She was sent for, but tragically drowned on the journey to Scotland. Alexander's death led to a political vacuum that left Scotland weak and leaderless. The English king Edward I forced an adjudication of who would be King of Scots, and the result was Edward Balliol, effectively a vassal of the English monarch. Insurrection raged, led by William Wallace, Braveheart and all that, and Robert the Bruce, with 20 years of Anglo-Scots war, resulting in Bannockburn and independence. Scotland then had to look for a new ally and turned to France, and out went Anglo-Norman common law and in came civil law. Over the next couple of 100 years, Scotland acquired the rudiments of a civilian legal system and a court structure expressly based on a French model. These fundamentals survived the union of the crowns in 1603 and of the two countries in 1707. Although the years since 1707 have ensured that Scotland was again drawn into the common law system, the traditional civilian roots of Scots law are still evident today, which is why our law is still littered with Latin maxims.
Our Scottish civil court system is hierarchical. At the very foot we have the sheriff courts, which are broadly comparable to the county courts in England. There are currently 39 sheriff courts in Scotland, and those are split into 6 different court areas for administrative purposes, which are known as sheriffdoms. Civil cases in the sheriff court are heard by a sheriff sitting alone.
Originally, sheriffs were appointed by the monarchy as the local representative of the king or queen overseeing judicial and administrative matters in their area on his or her behalf. It later evolved into professional appointment. To be appointed a sheriff, you must have been qualified as a solicitor or an advocate in Scotland for at least 10 years. You are then appointed by the Queen on the recommendation of the First Minister.
Disputes worth any sum of money can be raised in the sheriff court. There's no minimum or maximum amount. A new court, called the All Scotland Sheriff Personal Injury Court, was introduced in January 2016, and it deals with personal injury cases only. It's located within Edinburgh Sheriff Court.
All Scottish solicitors have a right of audience in the sheriff courts, although advocates, which is the Scottish equivalent of a barrister in England and Wales, are frequently instructed in more tricky cases. Appeals may be made from the Sheriff Court to the Sheriff Appeals Court.
Next up in the hierarchy is the Court of Session, which is Scotland's supreme civil court. The Court of Session is located at Parliament House on Edinburgh's Royal Mile. The building itself is absolutely steeped in history. As the name Parliament House implies, it once housed the Scottish Parliament. This was the pre-Union 1707 Parliament of Scotland, which sat in its magnificent Parliament Hall. The hall is still busy during court days now, with solicitors meeting their clients and their advocates, and advocates are traditionally seen pacing up and down the hall discussing their cases. They pace because the conversation's less likely to be overheard because of the acoustics in the hall. The Court of Session is a court of first instance as well as being a court of appeal. Because of this dual function, it's therefore comparable to the High Court and the Court of Appeal in England. It does not, however, have jurisdiction over disputes of a value less than £100,000, and these lower value disputes must be raised in the Sheriff Court.
The Court of Session is divided into the Outer House and the Inner House. The Outer House consists of judges known as Lords Ordinary, who hear cases sitting alone or in certain cases with a civil jury. However, civil jury trials are relatively uncommon in Scotland these days. Designated judges deal with certain specialist matters, and there are special procedures for intellectual property disputes, commercial cases, personal injury cases and family law matters. The Inner House is in essence the appeal court, although it has a small range of first instance business as well. It's divided into the first and second divisions of equal authority and presided over by the Lord President in the First Division and the Lord Justice Clerk in the Second Division. Each division is made up of 6 judges, but the quorum is 3. Sometimes, due to the pressure of business, an extra division of 3 judges sits. The divisions hear cases on appeal from the Outer House and from the Sheriff Appeals Court, and they also hear appeals from certain tribunals and other bodies. If it is necessary to overrule a previous binding authority, a larger court of 5 or more judges may be convened.
At the top of the hierarchy is the Supreme Court, which is the final court of appeal for the UK for civil cases. The right of appeal to the Supreme Court is not automatic. You require either permission from the Inner House of the Court of Session or from the Supreme Court itself in order to bring an appeal. There are currently 2 Scottish Justices of the Supreme Court, and it's been a long-standing convention that there should always be at least 2 Scottish judges in the Supreme Court.
In Scotland, each court has its own set of procedural rules, and each type of action has its own particular rules too. We do not have the equivalent of the White Book in England and Wales, but instead we have annotated rules for the Sheriff Court and the Court of Session, and these are divided into chapters covering each type of action. It's beyond the scope of our webinar series to look in detail at all the different sets of procedural rules, but instead we'll focus here on the general procedure in the Commercial Court of the Court of Session, which is where we most commonly represent clients in respect of some of the most complex and high-value disputes. Now, prior to raising a commercial action, it is expected that parties, where possible, will exchange correspondence setting out the respective positions and providing each other with any documents they seek to rely on. If the claim is one where an expert report will be required to be relied upon, then it too should be intimated during the pre-action correspondence. This guidance is embodied in a practice note issued by the court, albeit it is not a compulsory type of pre-action protocol that is common in England and Wales. Nonetheless, the court can take account of any failure to comply with this direction when considering an award of expenses in the case. Indeed, there is only one type of compulsory pre-action protocol in Scottish procedure, and that is in relation to personal injury actions worth up to £25,000. Beyond that, there is only voluntary pre-action protocol, including in respect of disease claims and professional negligence claims worth up to £20,000. Thereafter, in terms of kicking off an action, proceedings are commenced usually by way of a summons, although sometimes by way of a petition. A summons is used where a pursuer is seeking to establish and enforce a right against a defender, whereas a petition is used when the authority of the court is required to do something.
A summons runs in the name of the sovereign, and when you hear us talking about signating the summons, that is the process whereby the document has the royal seal or signet applied to it. The signet means that the pursuer has the authority of the court to proceed with service of the action on the defenders. A case is not independent until it's been served, and therefore service on the defender is necessary to stop the prescriptive clock from running. Up until very recently, there was no such thing as standstill agreements in Scotland. But a form of standstill agreement has just been introduced in the Prescription Scotland Act 2018, which received royal assent on the 18th of December 2018. At the date of filming this webinar, the Act isn't yet in force, so please do keep an eye on our website for updates. In any event, the type of standstill agreements which are coming into force in Scotland are not quite the same as those you will come across in England and Wales. The important point to keep in mind is that signating is not enough, and service of the defender is also needed to stop the prescriptive clock. There are also time limits on serving the summons on the defender. A summons needs to be served within a year and a day of signating, unless it's a personal injury action, in which case it must be served within 3 months and a day of signating. If it's not served in the year and a day, then the instance falls, which means that the authority of the court is lost and the pursuer cannot proceed. If you're not time barred, you can start the process again and apply for signet once more. There are similar rules in the Sheriff Court, but there we talk about warranting and getting the warrant of the Sheriff to serve the papers. Service of a summons can be carried out in a variety of ways. Usually it's served by registered post or personal service. For Court of Session cases, personal service is carried out by messenger at arms, who are akin to process servers or bailiffs in England and Wales. In the Sheriff Court, these officials are known as sheriff officers. In practice, messenger at arms are usually also sheriff officers.
If the defender is domiciled in Europe, then the period of notice given is 21 days. However, if they are domiciled further afield, then the period of notice is 42 days. Unlike in England and Wales, service by ordinary post is not effective.
We do continue to have quite technical pleadings here in Scotland. It's meant to be more relaxed than the commercial court, but the reality is we do still proceed with formal pleadings answered by way of lodging defences. After defences are lodged, there's a period of adjustment when both the summons and the defences can be adjusted. The period of adjustment may be continued on cause shown, but eventually we get to a position where a choice must be made on whether to proceed to a legal debate or to a proof, the equivalent of a trial in England and Wales. In a commercial court action, there'll be preliminary and procedural hearings along the way. When we talk about the matter going to a debate, this is an appointment to the procedural role in the Court of Session and is a hearing of legal arguments without evidence. Usually legal arguments are tied up with questions of facts and are dealt with at proof, but there may be cases where the answer to a legal question would dispose of whole or part of the case without evidence being heard, and that case may go to a debate. The party challenging the legal basis of the other side's case has to establish that, even if all they plead is true, it's insufficient in law to support their case. Sometimes legal arguments require the facts to be established first, before the questions of law can be answered, so a hearing called a PBA or a proof before answer will be fixed. We do not have a strikeout procedure as such in Scotland, although summary decree may be sought at an early stage where the defender does not disclose a defence. In the Sheriff Court, both the pursuer and defender can apply for summary decree on the grounds that an opposing party's case or part of it has no real prospect of success, and there are no compelling reasons why summary decree should not be granted.
Evidence is given orally on oath, although in the commercial court the practice is to lodge written witness statements, which are taken as evidence in chief. But such use of witness statements is pretty much limited to the commercial court and also to the family court. Witness statements should not be confused with precognitions, which are private statements of the witness taken by the solicitor for the purpose of recording the witness's evidence. A precognition taken privately is inadmissible in evidence, and parties cannot be compelled to disclose these.
We mentioned that in the commercial court, if you intend to rely on an expert report, you are expected to produce it during the pre-action protocol that applies to commercial court actions. But in professional negligence cases, whether in the commercial court or otherwise, no action can be raised without first obtaining an expert report. Unlike in England and Wales, the Scottish courts currently exercise very little judicial control over expert evidence. There's currently no code of conduct or guidance issued by the court on the form of expert reports or the information to be contained in the reports, although that is a recommendation in the ongoing civil courts review. The Law Society of Scotland has published an expert witness code of practice to assist experts in preparing reports and giving evidence.
As before, please check our website for any updates on legislative changes brought about by the ongoing Civil Court review. It should also be noted that there is no requirement for permission from the court to instruct an expert. The court must certify a witness as skilled in order to be able to recover the costs from the other side if successful, and there is no presumption that they will be so certified.
Disclosure of documents in the context of litigation is an area where the approach taken in Scotland does differ greatly from that in England and Wales. For instance, there is no general obligation to disclose in Scotland. Once a dispute has arisen, documents may be able to be recovered by agreement, but if the documents are not disclosed voluntarily, an application must be made to the court to compel the party holding the documents to disclose them. The person in possession of a document in Scotland is called the haver, and the haver can be any third party, not just the parties involved in the case, so it might be the HSE or the Crown, or more often than not it can be a solicitor. The method for asking a court to order disclosure of documents depends on if the action is live or if it is only in contemplation. Looking firstly at disclosure of documents prior to a court action. Parties contemplating litigation may want to see documents relevant to their case as part of the pre-action preparation, and the only way to achieve disclosure of documents before the action is commenced, and of course in the absence of voluntary disclosure, is by way of obtaining what is called a Section 1 order, and that is an order under Section 1 of the Administration of Justice Scotland Act 1972. A Section 1 order can be brought ex parte, that is, without giving notice to the other party. Those are often referred to as dawn raids, as when the Section 1 order is granted, the person considering bringing the action will often raid the premises of the persons holding the documents first thing in the morning to maintain an element of surprise and to protect against the documentation being destroyed. The test for an ex parte Section 1 order is very stringent, and there must be a real risk that evidence relevant to court proceedings is likely to be concealed or destroyed.
Our recent experience of Section 1 orders has been where we've been concerned that evidence held electronically will be deleted. The party making the application under Section 1 must have what we call a prima facie case. That is, an arguable case on the face of it, that the documents exist and that they may be relevant to later court proceedings that are likely to be brought. So-called fishing expeditions, where applications are made on the off chance that there may be relevant documents held, which could give rise to an unspecified claim, are not allowed. If a Section 1 order is granted, a commissioner is appointed, and that's usually a senior member of the Scottish Bar. And power is often given to the commissioner to remove documents or property and to employ such persons as he or she considers appropriate that could assist in the inspection and removal of documents. In our recent experience, that may involve the employment of an IT expert in order to properly search for electronic data that may be concealed. The Commissioner will be given power to enter into premises where it is thought the documents may be located and to search for and to open lock-fast premises. The Commissioner will be accompanied by a shorthand writer who acts as his clerk. Sometimes the court permits the petitioner's solicitor to accompany the Commissioner in order to identify property, but the petitioner's solicitor should not really assist the Commissioner, as that can lead to all sorts of conflict issues later on.
Looking at recovery of documents during a court action, as I mentioned, in Scotland, there is no general duty to disclose, and the court rules set out how documents can be recovered from third parties during a court action. A court will only order documents to be produced if the party seeking disclosure can demonstrate the documents are relevant to their claim and support its pleaded case. As with Section 1s, the court will not authorise fishing expeditions. There has to be written pleadings to support the production of the relevant documents, and that is to avoid fishing expeditions because, of course, you shouldn't plead any factual statement unless you know you can prove it. The application for recovery of documents during a court action is framed as a specification of documents, which requires the approval of the court. A specification expressed in too wide terms and without reference to the facts of the case will not be granted. It may also be refused if the terms are too vague.
There is a fine line between the need for evidence to elaborate an existing and known case and a fishing diligence, where one might be hoping to find something that would support a case that without it cannot be made. Accordingly, a specification of documents produced by one side will in all probability be argued over by the other side. When the specification of documents has been approved by the court, though, the solicitor seeking recovery has a choice as to the procedure to be adopted. He may use the optional procedure, which entails the serving of the order on a person believed to hold the documents who's requested to produce them voluntarily. When the specification of documents is approved, it's not necessarily the case that it will refer to a particular document held by a particular person. It may call for the production of all documents showing or tending to show X, Y, Z. The specification of documents and the court order will be served not necessarily on the other party to the action, but on any party that might be thought to be a haver. A haver may claim confidentiality, in which case the documents they produce must be placed in a confidential envelope and returned to the court rather than to the other party. And the court's authority will be required before the envelope is opened up. Alternatively, the party seeking recovery can go straight to what is called an open commission. And that is a diet at which havers will be cited to attend, and it's presided over by the commissioner. A haver will then be asked if they have any of the documents referred to in the specification of documents, and if not, whether they ever did have them, and what has happened to them since. A haver is entitled to be represented at the commission, and he's also entitled to a fee for the trouble in searching out the documents called for. Although, in the case of solicitors holding documents, that fee will not be at the solicitor's rate, but will be an appropriate fee for the administration that's been involved in searching out.
Difficulties arise where documents sought to be recovered are not located in Scotland. There are no means of enforcing an order for production of documents out with Scotland, and letters of request would require to be addressed to the appropriate foreign court. If, however, the documents held out with Scotland are in the hands of one of the parties to the action, the Scottish court will expect them to be produced.
Part 36 offers, like you might encounter in England and Wales, are not available in Scotland. Instead, judicial settlements are advanced by way of minutes of tender. These are regulated by case law precedents rather than formal procedural rules. Like Part 36 offers in England and Wales, to be effective, a tender must contain a settlement offer and an unqualified offer of expenses to the date of the tender. The treatment of tenders made by defenders is straightforward. If the court's award in the case is higher than the tender, then expenses are awarded as normal, i.e. the tender has no effect. If the court's award is lower than the tender, then expenses are only awarded as normal until the date of the tender, after which the pursuer cannot recover their expenses, and not only that, they must pay the defender's expenses during that period. So there is then, in effect, a double whammy for the pursuer who fails to beat the tender. The rationale here is that the pursuer should have accepted the tender as a reasonable settlement and therefore bears the expenses burden for the continuation of the action. Unlike in England and Wales, there is no 21-day period for acceptance, and a tender can be withdrawn at any time. The date of the tender in Scotland is not the date it was issued, but the date on which it ought reasonably to have been accepted, with the pursuer allowed a reasonable time to consider a tender. There is little case law guidance on how long a reasonable period is, but the later the tender in the course of an action, it is likely to increase the time allowed for its consideration. In Scotland, following a recent change to the rules, it is also possible for the pursuer to make a formal settlement offer known as a pursuer's offer. The case will settle if the defender accepts the pursuer's offer and will have to pay the principal sum offered, inclusive of interest and the pursuer's expenses, to the date of the offer. Where the court is satisfied that the pursuer's offer was accepted late, the defender is found liable for interest on the principal sum from the date of the offer and for payment of an additional sum of expenses to the pursuer. That additional payment is a 50% uplift on the pursuer's expenses for the period following the date of the offer. The rules also provide for the defender to be found liable for payment of the same additional 50% uplift in expenses to the pursuer where an offer is not accepted and where any court award is the same or better than the level of the pursuer's offer.
An important point to bear in mind about tenders is that, unlike in England, it's not possible to make an all-in tender, which includes expenses. So, for example, if I were to offer a tender for, say, £100,000 inclusive of interest and expenses, that would not be considered competent in Scotland. To be competent, the tender has to be for a principal sum plus an agreement to pay the judicial expenses, which are ultimately awarded by the accountant of court through a process known as taxation. It is possible to make an all-in offer in a founding letter, but just not in a formal tender.
Recovery of expenses, referred to as costs in England and Wales, generally follow success in the Scottish courts. However, the question is always one of equity. When an order of expenses is made by the court or an action is settled out of court and the losing side agrees to pay its opponent's expenses, the successful party prepares a judicial account of expenses in line with a table of fees. However, the table is not generous and does not go very far by way of indemnifying the successful party. We usually advise our clients that between half and 3/4 of what has been spent will be recoverable if a party is wholly successful. In an extrajudicial settlement, it may be prudent to try and argue that all actual expenses incurred are met as part of the overall compromise of the claim. Otherwise, if judicial expenses are to be met or awarded, an account of expenses is prepared and submitted to the Auditor of Court to tax and report. There are strict time periods for lodging accounts of expenses for taxation, and if these are missed, then it is likely that you will not be able to recover your expenses. The Civil Litigation, Expenses and Group Proceedings Scotland Act 2018 provides that in personal injury cases, unsuccessful pursuers may not be liable in respect of any expenses, irrespective of the lack of success, so long as they are not shown to have conducted the proceedings in an inappropriate manner. Now, this is now commonly referred to as qualified one-way cost shifting. However, the Act is not in force yet, as we await secondary legislation and rules changes in order to bring the various provisions into full force and effect and provide more detail on how they will operate in practice. Please check our website for updates, and in the meantime, it is worth noting that this particular provision will be restricted to personal injury cases, and there are various qualifications to it.
Counsel's fees are almost always recoverable in the Court of Session, although it is still possible for a party to argue that they are excessive or that the action should not have been raised in the Court of Session in the first place and it should have been raised in the Sheriff Court. In the Sheriff Court, solicitors also have rights of audience, and the Sheriff must sanction the involvement of counsel in a case. The Sheriff will usually do so in difficult or complex cases, but it's certainly not automatic. It is also possible to apply for sanction for counsel in advance, so that you don't end up at the end of the case having instructed counsel, only to find out that the court will not sanction their fee as part of your recoverable expenses. The involvement of an expert witness must also be certified by the court as reasonable, and the costs are recoverable in that case from the losing party. Recently, the Scottish courts have taken a more strict line with what is and what is not considered to be an expert opinion, so it's not necessarily a done deal that your expert will obtain the necessary certification in due course. We are often asked if an instructing in-house lawyer may recover their fees. In principle, it is possible for in-house lawyers to recover their expenses, although there's no real judicial guidance on the point. It's important that duplication of work will not be permitted, as the account of expenses is prepared as though only one solicitor was involved. It's also important that an in-house lawyer keeps a fully itemised breakdown of the time they spend on disputes and the work they have undertaken, if it's thought that there's going to be a real prospect of recovery of their fees in due course. As we have mentioned already, the fees which are recoverable are not very generous. A finding of expenses is at the discretion of the judge. Broadly speaking, there are two levels or scales on which expenses might be awarded against an unsuccessful party. The first is expenses on a party-and-party basis, and the second is expenses on a solicitor and client, third-party paying basis. The usual finding of expenses in Scotland is on a party-and-party basis. Party-and-party costs are those costs which are strictly necessary to conduct the litigation, so they're not as generous as the indemnity costs you would more commonly see south of the border. In some cases, a judge may award expenses on a solicitor and client third-party paying basis, and these are the costs which are reasonably incurred by the solicitor in protecting their client's interests. These costs are still not quite the same as the indemnity costs of the client, but they're more generous than the typical award in Scotland of party and party costs. Overall, it's worth keeping in mind that our cost system of judicial expenses is not as generous as south of the border. And as yet, we don't have a system of cost budgets during the course of the litigation. And as a result of this, what the likely recoverable expenses will be at the end of a case, or what the cost the client might be stung with if they're unsuccessful, can be more difficult to ascertain.
The Civil Litigation, Expenses and Group Proceedings Scotland Act 2018, which I mentioned earlier, includes provisions requiring that it must be disclosed to the court if a party is receiving third-party funding, and the court may then make an award of expenses against that funder or any intermediary if they have a financial interest in the outcome of proceedings. Importantly though, this does not apply to those engaged in a success fee arrangement, i.e. to a solicitor-client arrangement. The Act is yet to come into force and we await the secondary legislation and rules changes on that front. I have delivered a more detailed webinar on the topic of expenses, which compares and contrasts the system in Scotland and England and Wales, and also covers tenders, pursuers offers and Part 36 offers. So if you're interested, visit our website for a webinar on how to recover your litigation spend in Scotland. The funding landscape in England of course changed significantly in 2013. It's taken a number of years for Scotland to catch up, and even then in a more limited sense than in England. However, the Jackson reforms have no application in Scotland. The Civil Litigation, Expenses and Group Proceedings Scotland Act 2018 makes provision for damages-based agreements to be utilised and directly enforced by Scottish solicitors for the first time, but that Act is not yet in force. It was always possible for solicitors to enter into other types of success fee arrangements, such as speculative or conditional fee arrangements, and to be paid an uplift of their fees calculated as a percentage, but not of the damages awarded to the client. Third-party funding is now something which is considered more in Scotland, although again we are rather catching up with the position in England, principally because damages-based agreements are not yet permitted. After the event insurance is available in Scotland, and like in England and Wales, the premium is not recoverable from the other side. Please check our website for regular updates on fees and funding, and the introduction of damages-based agreements in Scotland.
The courts in Scotland can make an order that a party must put up security for the cost of an action, including the other side's costs, and this is known as cation. To do this, the party seeking cation must make an application to the court, or what we would call a motion to the court. If an order for cation is granted, it can subsequently be varied or recalled on a further application, or motion as we would call it, being made. Any motion, either for cation or for variation or recall, must set out the grounds of the application. Cation is not automatic, and the court has a wide discretion whether or not to order cation. There are a number of factors that a judge will take into account in deciding whether or not to grant cation. For example, they will look at the nature and scale of the litigation. If the type of the litigation, for example, is an appeal, that's going to mean costs are likely to be greater, and that may favour cation being granted. The judge will also consider whether the party against whom cation is being sought has been refused legal aid, and what the reasons for that refusal were. The judge will also consider the financial circumstances of the party against whom cation is being sought, and what means they have to pay a finding of expenses if the case were ultimately to be decided against them. The judge will also look at whether the case is being brought by the party in their own interest, or whether they are being used as a front for a wider interest. They will also consider the overall value of the claim and the likelihood of success. If an order for cation or other form of security is granted, the order will specify the period by which cation or security must be found. This can be done by lodging a sum of money with the accountant in court, or through what's called a bond of cation, and that's usually a bond issued by an insurer. The court may also approve of other methods of security or a combination of these methods. If a party is required by the court to obtain cation and fails to do so, there can be very serious consequences. If the party in default is the pursuer, i.e. the claimant, the defender can seek a decree of absolvitor, which is a judgment that they are absolved of all liability for the claim. If the defender, on the other hand, is the one in default, then the pursuer can seek decree by default, basically a default judgment against the defender, or such other order as the court may see fit. The basic idea behind the rules on cation is that no party should be obliged to litigate against a man of straw.
Once you have got to the stage in a litigation where the matter has been determined and an award of expenses has been made, the unsuccessful party may look to appeal. The procedure adopted depends on whether your action is in the Sheriff Court or in the Court of Session. Since January 2016, appeals from the Sheriff Court must be brought to the Sheriff Appeals Court. Where the decision of the Sheriff is a final disposal of the case, whether that's after a proof where evidence has been heard or at a procedural hearing where legal arguments have been canvassed, the appeal is made without the leave of the Sheriff who made the decision. It must be made within 28 days after the date on which the decision was given. A note of reasons of the decision from the Sheriff whose decision is being appealed must be obtained, and then the appeal is intimated to the other parties and sent to the Sheriff Appeals Court. The Clerk of Court will then issue a timetable setting out the procedure to be followed. Appeals beyond the Sheriff Appeals Court will require leave of either the Sheriff Appeals Court itself or the inner house of the Court of Session to whom the appeal is made. Where the Court of First Instance is the Court of Session, the appeal is made from the outer house to the inner house. The process is known as reclaiming, and it's made in the form of a reclaiming motion. There are 3 general time limits depending on the type of decision being reclaimed. Interlocutors, that's what we call the order pronounced by the Lord Ordinary, and they may be reclaimed within 21 days after the date on which the interlocutor was pronounced. Certain other interlocutors that do not dispose of the whole case may be reclaimed without leave, but within a 14-day period, and these include interlocutors granting or refusing interim interdict and interlocutors disposing of part of the merits of the case. In all other interlocutors, leave is required, and the reclaiming motion must still be made within 14 days, so the leave must be obtained within that period. Once the reclaiming procedure is underway, the court will issue a timetable specifying various procedural steps, such as the lodging of the grounds of appeal and answers, notes of argument, any appendices containing the material that's to be relied on. Like in England, new evidence can only be submitted if it could not with reasonable diligence have been available during the original hearing, and of course, it must be relevant to the matters at hand. What are the remedies available to a party in Scotland? Well, broadly speaking, there are 5 main remedies. In Scotland, our judgments are called decrees, and so we have decrees for payment or for damages, decrees declaring a factual and legal position, such as a declarator, decrees reducing contracts or deeds, decrees interdicting something from being done, and decrees of specific implement requiring something to be done.
Decree repayment is self-explanatory. It's payment of a sum of money due under a contract. Damages can relate to both contractual and delictual obligations. In English law speak, that is damages arising from a contract or a tort. These are purely compensatory, and the Scottish courts do not permit punitive damages unless they are allowed under statute.
A decree of reduction has the effect of annulling a deed or writing. An alternative to seeking reduction is to ask the court to set the document aside ope exceptionis. That's a nice little Latin phrase which has crept in from our civil law background. Basically, what that means is that the court will set a document aside as part of a broader action, in which case the invalidity of the document has no effect beyond the particular litigation. Interdict is the Scottish equivalent of injunction. It is a remedy granted by the court either against a wrong that is in progress or one that is reasonably apprehended. Where a case has been fully considered at proof and evidence has been led and the defender's actions have been found to be unlawful, the pursuer is entitled to interdict alongside whichever other remedy may be sought. If an interdicted party fails to observe the interdict, he may be liable to punishment by fine or even imprisonment.
Interim interdict may be granted on a temporary basis during the currency of a litigation to prevent an imminent wrong from happening. Before it will grant interim interdict, the court must be satisfied the party has made it a prima facie case and the balance of convenience favours the granting of the interim interdict. Interim interdict is granted at the risk that damages will be awarded against the applicant should the interim interdict be recalled or perpetual interdict be refused and the defender has suffered loss as a result of the interim interdict. Another little Latin phrase we like to use is that interdict is sought periculo patentis.
Sounds like a spell, but it just means you take it at your peril. Specific implement is where the court orders the performance of some act which the defender is under a legal duty to perform. The decree is called a decree ad factum praestandum. I told you we liked our Latin phrases. An example of specific performance is a decree for removal of an encroachment. Decrees sought must, however, be specific. That's so the defender knows what's expected of them, and performance must be possible. You can obtain an interim specific implement as you can an interim interdict. The court has to be satisfied that there's a prima facie case and that the obligation sought to be implemented exists and that the balance of convenience favours the granting of the interim order. There are other interim orders that can be sought, for instance, an order for delivery or removal.
The technical name for enforcing judgments in Scotland is called diligence, and Thomas and I are going to give a very high-level run-through of some of the most commonly used form of diligence we have in Scotland. The first thing to mention when we talk about enforcement methods in Scotland is really the charge for payment. A charge for payment is a prerequisite to some forms of diligence being carried out, such as an earnings arrestment and attachment of goods. We will come on to talk about those shortly. A charge for payment is a formal demand for a sum of money. It specifies the sums due in terms of the decree and also includes a prescribed fee for the cost of serving the charge, as well as typically an amount of interest. The charge for payment is served on the debtor by an officer of the court. In the sheriff court, they're called sheriff officers, and in the court of session, they're called messenger at arms. They're akin to an English law bailiff. The charge for payment can often be an effective enforcement method in and of itself, encouraging a debtor to make payment without further action being taken or to discuss the debt with the creditor and make proposals. The charge for payment allows the debtor 14 days to pay the debt, and if the debtor fails to do so, then the creditor can instruct the sheriff officer or messenger at arms to carry out diligences on their behalf to recover the sums of money. Failure to pay the charge within the 14 days also constitutes apparent insolvency, which can found the basis of a petition for bankruptcy of an individual, or sequestration as we would call it in Scotland, or for the winding up of a company. A charge for payment lasts for a period of 2 years, and once the charge expires, if payment has still not been made, further charges can be served on the debtor. The first form of diligence we are going to talk about are arrestments. Arrestments are used where money or movables belonging to the debtor are held by a third party. The arrestment is served on the third party and prohibits them from transferring the money or movables to the debtor. In most cases, a charge for payment is not required to serve an arrestment. One of the most common forms of arrestment used in Scotland is the bank arrestment. The arrestment is served on the debtor's bank, freezing funds belonging to the debtor. If the debtor does not pay the debt or agree to release the funds are automatically released after a period of 14 weeks. Where individuals are concerned, there's a minimum protected balance, and only sums over that minimum protected balance can be attached. This is to prevent hardship to ensure funds are available for basic living expenses of the debtor and their family. It's important to bear in mind that arrestments are time sensitive, and as a result, they're often speculative in nature. So for example, if I were to serve a bank arrestment today, it would only catch what is in the debtor's bank account today at the time it is served. If the debtor paid £1 million into their account tomorrow, that wouldn't be caught.
Wages arrestments are a special form of arrestment served on an individual's employer and obliges the employer to make a deduction from the debtor's earnings. To carry out a wages arrestment, the creditor needs to first serve a charge for payment on the debtor. The amount of the deduction is determined by a statutory scale, depending on the income and the frequency of the debtor's pay, and this is updated from time to time. For those on very low incomes, there is a level at which no deduction is permitted, and this again is designed to prevent hardship on the debtor. The next type of diligence we want to discuss is attachment. Under an attachment, goods belonging to a debtor are seized with a view to their ultimate sale by auction. The sheriff officer or messenger at arms will prepare an inventory and valuation of the movable property of the debtor, and the attached items may subsequently be auctioned and the proceeds distributed. In the majority of cases, the threat of assets being sold at auction prompts the debtor to pay the debt or to make proposals. Where individuals are concerned, special rules apply. To attach goods inside a debtor's home, special orders must be obtained from the sheriff court and cause must be shown. These orders are called exceptional attachment orders, and as the name implies, they really are exceptional in nature and rarely sought in practice. Where individuals are concerned, there is also a long list of exempt assets which cannot be attached, and again, these are rules designed to prevent hardship to the debtor and their family.
One of the most commonly used and effective forms of diligence used in Scotland is an inhibition. An inhibition is considered as a so-called freezing diligence, as it preserves the debtor's estate. The inhibition is an order prohibiting the debtor from dealing with their heritable property, and that covers not only them transferring or selling their property, but also stops them from burdening the property with standard securities, i.e. mortgages. The inhibition requires to be served on the debtor, and it is then registered in an official register called, funnily enough, the Register of Inhibitions. An inhibition lasts for a period of 5 years and covers all of the debtor's heritable property in Scotland. Unlike a charging order in England and Wales, an inhibition is not a form of security per se, but they are still incredibly useful. If a debtor wants to sell their property or obtain further securities, they will need to have the inhibition discharged, and that invariably means engaging with the creditor, who will no doubt insist on payment. A charge for payment is not required to be served for an inhibition, so this form of diligence can be carried out more quickly. Rules of time bar are of pivotal importance to practitioners and also to clients in any jurisdiction. The law of time bar, or prescription and limitation, as we call it in Scotland, is regulated by the Prescription and Limitation Scotland Act 1973, and this Act applies to all claims where the underlying obligation is governed by Scots law. A new Act has recently been introduced called the Prescription Scotland Act 2018, and it obtained royal assent on the 18th of December 2018. It will amend the 1973 Act, and I will be coming on to speak about some of the key changes later in this webinar. At the time of filming this webinar, the substantive provisions of the 2018 Act have not yet come into force, and transitional provisions have not yet been confirmed, so please do keep an eye on our website for updates.
Prescription has the effect of extinguishing a right or obligation completely after a period of time has passed. This is a matter of substantive Scots law, and it's applicable wherever litigated. Limitation, on the other hand, does not extinguish rights or obligations, but introduces a procedural bar on raising legal proceedings. Under the 1973 Act, standstill agreements are of no effect in Scotland. The only way to avoid the claim being lost through prescription or limitation is to effectively serve proceedings on the defender. Unlike in England, it's the date of service of the writ that stops the clock, not simply the date of lodging proceedings in court. There's a 20-year long stop for avoiding stale claims, and this starts when there is a concurrence of injury and damage, or injuria and damnum, to use the Latin we love so much.
So what are the prescriptive periods? The time periods vary depending on the type of claim you're dealing with. Claims to pay money or compensation in contract or in delict, i.e. tort, tend to be the most common claims encountered by clients. For these types of claims, the prescriptive period is 5 years from the date of breach of contract or from breach of duty, subject to rules as to when the clock starts ticking. Note it's 5 years in Scotland, not 6 years as is the case in England and Wales, and that can sometimes trip up claimants who are more used to dealing with the English rules and think they have more time than they actually do. We also do not have the same concept of primary and secondary limitation as you do in England and Wales. There are, however, some limited circumstances in which the clock may start at a later stage. The 5-year period I spoke about is frozen during any period during which the creditor was induced to refrain from making a relevant claim by reason of fraud on the part of the defendant or any person acting on their behalf, error induced by words or conduct of the defendant or any person acting on their behalf. This does not include any time after which the creditor could, with reasonable diligence, have discovered the fraud or error. For certain claims relating to property, the prescriptive period is much longer, at 20 years, and there are different periods for claims in relation to defamation, harassment, product liability and personal injury.
The law of time bar has been a hot topic in Scotland since late 2014, following the decision in a Supreme Court case, the case of ICL Plastics. This case overturned around 30 years of what was believed to be settled law about when the clock starts to run. The Supreme Court held that the way in which the Scottish courts had for those 30 years interpreted the Act was wrong. The 5-year period starts on the date the claimant knows they have suffered loss, injury or damage, or the date on which with reasonable diligence they could have known they had suffered loss, injury or damage. There was no need for a claimant to be aware of the identity of the defender or that they had an actionable claim in law, as had previously been thought to be the case by the courts. This decision was regarded by many as being unfair and means that the prescriptive clock in Scotland can begin at a very early stage indeed, and possibly much earlier than would be the case in England and Wales on similar facts. Following on from the decision in ICL, there were various calls for reform of the law. It was considered that the decision was very harsh for claimants, especially since claims could potentially time bar in Scotland when a claimant didn't even know the identity of the defender.
The Scottish Law Commission were asked by the Scottish Government to consider the law in this area, and a new bill was introduced following a consultation exercise. The Prescription Scotland Act 2018 obtained royal assent on the 18th of December 2018 and brings into force a number of the Law Commission's key recommendations. The 2018 Act amends the 1973 Act, and so whilst there's a number of important changes, this is not a wholesale revision of the law in Scotland, and the majority of our rules on time bar remain unchanged. The first of the changes under the Act is the introduction of a new discoverability test. The second key change is the introduction to Scotland of standstill agreements, and Elaine's going to talk about that later. And the third change is a change to how our 20-year long stop period is calculated. Taking each of these in turn. The new discoverability test is a test which has been devised to seek to deal with ICL and addresses what were considered to be the harsh consequences on claimants as a result of the decision. The new test under the Act has 3 strands. The claimant must be aware, firstly, that loss, injury or damage has occurred. Secondly, that loss, injury or damage was caused by a person's act or omission. And thirdly, they must be aware of the identity of that person. It's important to bear in mind that this new test does not, however, reinstate the law as it was previously understood prior to ICL, but rather the test seeks to strike a balance between claimant and defendant. As is the case under the ICL decision, a claimant does not need to know that they have an actionable right in law.
The lack of standstill agreements in Scotland has long been criticised as hindering parties who are seeking to negotiate claims and leading to unnecessary cost for parties who require to raise protective proceedings in order to avoid the claim becoming time barred. The new Act will allow parties to enter into standstill agreements. However, there are restrictions, and Scottish standstills are not going to be the same as or as flexible as parties might be used to in England and Wales. A standstill will operate to extend the 5-year prescriptive period. However, it will only be available when the prescriptive period has started to run, only one standstill agreement can be entered into, and the maximum duration of that standstill is 1 year. So you could not, for example, agree to a standstill of a year and then, if you didn't settle, agree to another standstill or extension. It's unclear how much these limited standstills will be utilised in practice once the Act comes into force, but their introduction is certainly to be welcomed.
One of the other changes coming in from the new Act is to our 20-year long stop period. Under the 1973 Act, the 20-year long stop period runs from the date on which an obligation becomes enforceable. As Elaine mentioned earlier, to start the 20-year clock running, there must be a concurrence of injury and damage, or injuria and damnum to use the Latin. Depending on the circumstances, the damnum part of that test, that is the loss, injury or damage, might be incurred many years after the wrongful act or omission took place. As a result, under the present law, it is possible for a long period to pass before the prescriptive period will start to run. This was seen to undermine one of the key aims of the rules on time bar, which is to prevent stale claims, as well as causing considerable practical issues for parties in pursuing or in defending claims. Under the 2018 Act, the 20-year long stop period starts on the date the act or omission took place. It will also not be possible to extend the long stop period by way of a standstill agreement. These changes were thought to better ensure that it is indeed a long stop, not only in name but also in effect, and were also considered to improve certainty for parties.
Another important matter treated differently in Scotland is the matter of privilege and confidentiality and without prejudice statements. Looking firstly at privilege and confidentiality, court hearings in Scotland are normally held in public. Written pleadings and documentary evidence lodged are only available to the parties and to the judge. The importance of establishing that privilege exists over key documents is that it allows an organisation to maintain a degree of control over the information that is passed to the other side and to the court. In Scotland, as in England, two grounds of privilege are recognised: legal advice privilege and litigation privilege. There has been very little judicial authority on privilege and confidentiality in Scotland. The law up here is far less developed than it is in England, I think perhaps as a result of the much higher volume of cases in England and Wales, and also as a result of the more onerous disclosure requirements of English litigation, which make privilege a live issue on a more frequent basis. Legal advice privilege, or legal professional privilege as it is sometimes called, is given to communications between a lawyer and a client. The purpose of the privilege is so that a client can have unrestricted confidence in his or her lawyer. The courts will only order disclosure of privileged communications between a lawyer and a client in very limited circumstances, and that is either where the client waives the privilege or where the communications concern an illegal act and a solicitor is concerned in the illegality. The types of communication to which legal advice privilege applies are those which are for the purpose of giving or receiving legal advice about what should prudently and sensibly be done in the relevant legal context. So, pure business advice is not caught by the privilege. For example, strategic or commercial advice will not be covered as it lacks the relevant legal content. Communications with third parties, for example external experts or witnesses, are not covered by legal advice privilege. They may be covered by litigation privilege, which we'll deal with in a moment. As in England, legal advice privilege is very unlikely to extend to other professionals beyond lawyers, and it does not automatically extend to communications between an in-house solicitor and his or her client. It must be shown the business employee is authorised to seek and receive legal advice. Litigation privilege is a wider type of privilege and protects confidential material that a party has made in contemplation of litigation, where the material was necessary for the sole or dominant purpose of the litigation. Privilege attaches as soon as litigation is reasonably contemplated, and up here the Scottish courts have taken a broad view as to when litigation is reasonably contemplated. This may be wider than the approach taken by the English courts. In Scotland, proceedings do not have to be commenced formally for the privilege to apply, although litigation must be a real likelihood as opposed to a mere possibility. Unlike legal advice privilege, litigation privilege extends to communications with third parties, for example external experts and witnesses. As in England, the starting point in Scotland is the court process is open. The court rolls are published daily and found on the Scottish Court's website, and they list the cases that are calling in court and in respect of which there may be hearings. Most hearings of the Court of Session, and indeed the Sheriff Court, are open to the members of the public. As in England, a wide range of judgments, including earlier decisions, can be found in court reports and are accessible using services such as Westlaw and the Lexis Library. Parties' names are anonymised only in family action involving children and in some arbitration appeals, and in certain cases when an application is made to the court under the Contempt of Court Act 1981. We all put without prejudice at the end of our letters and communications. It's often overused by non-litigation lawyers, but the underlying reason for using these words in Scotland, England and Wales is the same. It's to encourage parties to resolve matters out of court and to prevent statements made in a genuine attempt to settle from being put to the court as evidence of an admission against the interests of the party that made them. However, the Scottish courts do take a different approach to the concept of an admission to that taken by the courts of England and Wales. The courts of England and Wales have given the words without prejudice a fairly wide meaning in the sense that it effectively includes all matters disclosed or discussed in without prejudice communications, and the rationale for this seems to be that dissecting out identifiable admissions and withholding protection from the rest of without prejudice communications would create huge practical difficulties, as well as being contrary to the underlying objective of encouraging the parties to speak freely in trying to settle their disputes. Without prejudice correspondence in England and Wales then seems to us sacrosanct, save in the face of a compelling policy reason. In Scotland, there's a distinction between statements made in an attempt to achieve an out-of-court settlement and admissions of fact. The privilege only attaches to the former, not the latter, so admissions of fact are not privileged in Scotland, and that's really to demonstrate the different approach taken north and south of the border. The English approach appears to be more context-based and the Scottish approach more content-based. In Scotland, the words without prejudice do not themselves give protection. We have to look at the content of the communications. So if, for instance, there's a clear acknowledgement that liability is accepted, the addition of the words without prejudice will not necessarily prevent the statement being founded upon in court. If a statement of fact is not later to be used against a party, it must be clear that it is a proposition made for the sake of settlement and not an unequivocal admission of facts. Using the words without prejudice does not automatically prevent the communication from being admissible in the Scottish courts, and that's the fundamental difference between us north and south of the border. We do find here there are a variety of ways in which without prejudice is communicated. Some solicitors have elaborate wording at the end of their letters that can stretch to lengthy paragraph, but basically all that is required is for the letter or email to state that it is written without prejudice to the client's whole rights and pleas, and it may not be founded upon. And as we've discussed, in Scotland, that protects the offers made, but not the assertion of any fact.
Another procedure, which may be unique to Scotland, is our system of caveats. A caveat is a document lodged in court by a party to ensure that they are given notice of certain preliminary applications. A caveat in Scotland is not directed to a particular party, but rather to a particular type of application. It will catch any application made by anyone seeking such interim orders against the caveator. Orders covered are interim interdict, our equivalent of the English interim injunction. Certain other interim orders, such as winding up or the appointment of an administrator, are also caught by caveats. Applications seeking such interim orders are more often than not heard ex parte, i.e. they're not intimated to the opposing party, so a caveat is a means by which you get prior notice. The caveator is given an opportunity to appear at the hearing for such interim orders. Generally, the court will agree to postpone the hearing for 24 to 48 hours in order to give the caveator time to prepare and be represented, although if the matter is extremely urgent, all that is required is that notice is given. It's prudent for commercial entities to maintain caveats in the courts which may have jurisdiction over them. Caveats last for a period of 1 year and accordingly require to be renewed annually, but they can provide essential protection to clients. It's far better to argue that an interdict should not be granted against you than it is to seek to have the interdict recalled in due course. An interdict, if granted, may have huge ramifications for a business up until the time it is recalled. Caveats can be lodged in multiple sheriff courts as required, and also in the Court of Session, as well as in the Scottish Land Court. There's a small fee of under £100 for each caveat lodged, and they really are invaluable for the possible protection they give.
While we are talking about differences north and south of the border, it's worth touching on the cross-border assistance which is provided under Section 27(1) of the Civil Jurisdiction and Judgments Act 1982. The Court of Session has discretionary power to grant a number of interim protective measures where proceedings have been commenced but not concluded in a foreign jurisdiction, including in another part of the UK. These interim measures can include an order for arrestment of any assets in Scotland, inhibition orders over heritable property in Scotland, and interim attachment orders and interim interdict, all of which we've discussed in our webinar on enforcement of decrees. These orders can be hugely important to claimants to ensure that assets in Scotland are safeguarded and not disposed of while the foreign proceedings are progressed. The Court of Session has also power to grant interim interdict, that is, interim injunctive relief, as you might know it in England, where proceedings have not yet commenced in the foreign jurisdiction. So if you are considering or have raised proceedings in England or Wales, you might want to consider seeking orders in Scotland in the Court of Session for interim protective measures should the need arise.